asking the court to sentence her to 19 months consecutive.
I don't need to tell you what drugs is going to take away from you. You've lost kids. You've lost, where somebody's just accumulating so many felonies, there's nothing left to do. As a judge thinking about whether prison's appropriate.
Those explosive moments you just watched, that is a judge pushed to his absolute breaking point. But what really triggered this emotional confrontation? The truth goes much deeper than you think. This is the sentencing of Vanessa Williams. On the surface, it looks like a standard drug case, but it's actually about a mother who already lost her children, now facing 19 months of hard consecutive prison time. The timeline is bizarre. How do you get caught with heroin in 2021, but somehow avoid arrest until 4 years later in 2025? Prosecutor Melissa Gish demands maximum punishment for 7 felonies. But is Vanessa a dangerous criminal or just a tragic addict? If you want to understand true courtroom psychology and see how the justice system wrestles with these impossible moral decisions, hit subscribe. Let's step inside the courtroom and see exactly how this unfolded.
All right, back on the record, we have People v. Vanessa Williams for sentencing. It's 25-7111 and 25-7112. Counsel, you want to state your appearances, please?
Melissa Goodrich, Bergen County Prosecutor.
And James Gilbert here on behalf of Ms. Williams.
All right, looks like we're here for sentencing on possession of heroin, habitual second with a 0 to 21 range, and absconding habitual second with a 10 to 28 range for the guidelines. Have you had a chance to review the report and recommendations?
Yes, we have gone through them. We have no additions or corrections or scoring challenges.
Okay, any from the people?
Your Honor, the kid score, PRV 7 was scored at 20 points for the possession, but not for the absconding. So I would ask that PRV 7 also be scored for 20 on that one. Because we're being sentenced here today on 2000.
Okay, Mr. Gilbert.
So my argument would be that they were separate in time and independent of each other, and as that it does not be scored as 20.
The absconding was absconding from the first case.
Oh, that's right. Well, let me see here. The so the possession is a 2021 offense date, right? So
yes. But she wasn't picked up and arraigned on it until September 14th, or maybe July 14th of 2025.
Oh, when did she fail to appear? In 2025 or in
No,
2025?
yeah, in 2025 on the prelim after she.
Oh, okay. So
yeah.
she wasn't arrested until 2025.
Yes.
So arrested in 2025, then absconded, and then has been convicted in 2026 for the possession and the absconding. All right, score the appropriate value if the offender was convicted of multiple felony counts or was convicted of a felony after the sentencing offense was committed. So for the possession, which occurred in 2021, she certainly has enough subsequent felony convictions. Wait, does she? Yeah, in June of, okay, February 17th, I'm looking at conviction 21 of 23 in Genesee County. A plea of February of 2026 and a sentencing disposition of March 17th. And that was was lying to a peace officer 1 to 4 crime investigations. Is that a felony or misdemeanor? That's misdemeanor. Okay. So she's got the possession of methamphetamine there. And then the absconding. Okay, so in the possession of heroin case, it's properly scored at 20 points based upon a subsequent conviction for possession of methamphetamine and a concurrent or subsequent conviction for the absconding. In the absconding case, that was committed in 2025. September. There's no subsequent conviction. So is it a concurrent conviction? I think I would consider the possession of heroin a concurrent conviction when she's pled and sentenced at the same time. Those are in fact concurrent convictions. She's convicted concurrently. And the only time gap is a result of her absconding. So I think that the possession of heroin does count as a concurrent conviction, but that would only be one, not two. So I would score in the absconding prior record variable 7 at 10 points, not 20, but not, I'll grant you the 10, Ms. Fitch.
Thank you.
And that increases the total PRV to 70 points. And on the F grid, does that change the range? No, it would remain on the E grid. So the range would remain the same. All right, Mr. Gilbert, anything you want to say on your client's behalf?
Yes, Your Honor. She has an ongoing case of Genesee, correct? And I just want to make sure I have my counties correct, where she's waiting, and part of that the program that they have for her is that she has to get what's done here resolved. She'll be going back to Genesee, assuming that this works out, and then she would be waiting for a bed for treatment. I believe this was all reflected, and I know the court reads the PSI, so I'm probably just repeating what the court already knows, but that and then she'd be getting a bed at treatment, and that program is supposed to last for approximately 3 months. The thing that would be over her head in that case is if she doesn't complete treatment, Genesee will be sending her to prison. So what I'm asking in this case is that I just don't believe any additional time from today. I know the recommendations for a year. I would ask that the court sentence her to time served, then let Genesee take over and get her into treatment. And again, if she fails there, then Genesee will be sending her to prison. So that, and like, as I'm saying, I don't think an additional jail, unless the court is inclined to send her to prison, which I hope is not the case, additional time in our jail probably would serve no purpose. So I would ask the court to give her this opportunity. I know she doesn't have a good history of when it comes to the absconding, but I think she has enough hanging over her head with, if she does not make Genesee happen, she is going to prison. So there's a great motivational there, and I'd ask the court to take that into consideration. Thank you.
All right, thank you. Ms. Williams, you don't have to tell me anything today, but you're welcome to. Is there anything you want to tell me or not?
Yeah, I have been using for a long time, and I mean, I guess no matter which way you cut it, I know my life will change from now forward. Sorry, no, but so I mean, I don't know. I know that it counts on me, like, well, it's me, so I'm gonna, you know.
All right, thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, thank you. Just going over the timeline here on January 25th of 2021, the defendant was found in possession of heroin in Sheboygan County, but not picked up on that warrant, as we discussed, till July 14th of 2025. Back on June 17th of 2025, the defendant was in possession of methamphetamine and lied to a police officer in Genesee County. On June 23rd of 2025, the defendant was again in possession of methamphetamine in Genesee County and also possession of a controlled substance less than 25 grams. And then on September 9th of 2025, she failed to show for her preliminary examination in Sheboygan County. Shortly after that, she also failed to show for her preliminary examination in Genesee County. She was later found and transported to the Genesee County Jail, so the case is resumed, and then also with the new absconding case. The defendant is 31 years old. She was 17 at the time of her first arrest. She now has 7 felonies and 15 misdemeanors. She's been to jail already 13 times. Probation has been tried 6 times. Her current status is that she's on probation in Genesee County for those 2 drug cases. She's on probation in the 67th District Court for retail fraud with a show cause hearing scheduled this month. She has a warrant for possession of methamphetamine, a count organized retail crime, and a possession narcotic under 25 grams in the 70th District Court in Saginaw, and also currently a failure to appear warrant for retail fraud out of the 52nd District Court. She's unemployed with an 8th grade education. The guidelines for the possession of heroin are 0 to 21 and absconding 10 to 28. The absconding is discretionary consecutive. The PSI is recommending 12 months jail for both charges with credit of 236 days and 233 days. The people are recommending, since jail has already been tried 3 times, to not do the 12 months jail again, given her criminal history. She, if we look through her criminal history, has had steady theft and drug crimes since 2017 in multiple counties in Michigan and some even in Florida, along with her absconding behavior in this case, as well as a pending case, including a failure to appear right now. The absconding should be at a minimum of guideline range. I'm asking the court to sentence her to 19 months consecutive to the drug case, with credit for time served on the drug case, but 0 credit on the absconding in 19 months. I think that would address the sentencing goals of deterrence as well as punishment, since rehabilitation does not appear to be a realistic goal at this time, given her decisions and actions. Thank you.
All right, thank you. Well, Ms. Williams, when you've got here, we've got a defense attorney and a prosecutor both doing their jobs really well, because they're both telling me true things about you. All those things that they both said are all true, right? Because people are a mix of good and bad, and it's rare that you encounter somebody that's all good or all bad. And you've already, I don't need to tell you what drugs is going to take away from you. You've lost kids. You've lost, I don't know if you've had much employment. You don't have much education. You've had some crummy things happen to you. You've done some crummy things. You've got some mental health struggles as well. Drugs have contributed to all those things. So drugs is just robbing you of every single good thing that's available in this world. So all the stuff that happened to you in the past, you can still have some good things in this world, but not with drugs. You already walked that path long enough that there's nothing there but darkness for you. The prosecutor's right. You got a bunch of prior felonies. You're absconding in this case. You got guidelines in both of these that would let me send you to prison. Discretionary consecutive. But what I didn't hear, what I don't see when I look at this history is deliveries. They're all possessions. Not just that they were pled to possessions, they're all charged as possessions. So, it's tough to find judges, and it should be hard to find judges who are real excited about sending people to prison for possession. I've done it sometimes. I don't like it. I've done it, but when I've done it, it's exactly this, where somebody's just accumulating so many felonies, there's nothing left to do. So you're in an environment now where even possessing drugs, given your lengthy history, as a judge, hang on, you don't want to do that. As a judge thinking about whether prison's appropriate. I'm not sending you to prison today. I just want you to know you're in the ballpark now where you're close to going to prison for just possession. In this case, I've got a 2021 traffic stop. Miss Williams is a passenger. She's got a personal use amount of heroin with her. It's charged in 2025. She's arrested in 2025 on it. Then she fails to appear and gets an absconding charge as well. There's no indication of more criminal charges or convictions after the date that she absconded. So I think there's no aggravating factors for that absconding that would cause me to think about consecutive sentencing. So in the exercise of my discretion, I'm going to do concurrent sentencing and not stack the cases. Mr. Gilbert gave some good reasons why time served would make sense, and I even wrote some notes to myself that there's some reasons why that might make sense to allow you to begin the New Paths program in probation in Genesee. You know, the prosecutor made a reasonable pitch for why you should go to prison, and I'm not doing that. Where the guidelines, especially in the absconding, are 10 to 28 months, it's kind of hard to justify, a downward departure. Shoot, even lower end is tough to justify given your history. So I think the recommendations from the Department of Corrections, I think, are pretty measured and pretty proportionate. So I'm going to adopt those. And in both these files, order that you serve 12 months in the Sheboygan County Jail, give you credit for 236 days served in 7111, 233 days served in 7112. And those will run concurrent with each other. In 7111, there's state cost of $68, crime victims assessment of $130, and court costs of $350. In 7112, there's state cost of $68 and a crime victims assessment of $130. I will indicate, you've already got credit for a bunch, so I don't know whether you'd be eligible for these other programs, but to the extent you've got more time to do in Sheboygan County Jail and would qualify, I'll put on these judgments. I have no objection to Ms. Williams participating in either CBT programming or trustee program with credit if the jail determines her to be eligible for those. And Ms. Williams, if you wanted to file an appeal in either or both of these cases, you'd have to file an application. If you wanted a lawyer, you'd have to ask me within 6 months. So we're going to hand you some piece of paper about your appeal rights. We're going to ask you to initial one copy in each file, so we have a record we gave it to you. The other one's for you to fill out if you want to take an appeal. So bottom line, it's 1 year. You're sitting on about 9 months credit, almost not quite, about 8 months credit. So you got a couple more to do if you get good time, and then you go off to Genesee, and good luck. Good luck to you on probation.
The judge made his final call. Vanessa dodged state prison for a lighter county jail sentence. But here's the real question. When authority faces a chronic offender, where is the line between justice and mercy? Comment below, are you team prosecution demanding strict consequences or team defense fighting for rehabilitation? If this moral clash got you thinking, hit like. Share this with anyone fascinated by the real psychology behind courtroom verdicts.